On our podcast today, we are going to be, first of all, getting to know Jason a little bit. We'll then be moving on to discuss some recent changes to harassment law. Now, when we are discussing that, because of the rules on YouTube, some of our wording will be, in effect, bleeped out. So just to give you a heads up in that regard, if it sounds that we're speaking slightly strangely there. We will then move on to discuss the future changes that are being proposed around the changes to flexible working requests, the law concerning unfair dismissal and the right to bring an unfair dismissal claim from day one. And finally, we'll be discussing the right not to be disturbed, which is in place in a lot of jurisdictions, but is finally getting to the UK during the course of the next 12 months. And to clarify, nothing in this podcast is intended to be legal advice. If you want to get some legal advice, click on the links below and get in touch with us, and we'll be happily able to provide it. Welcome to the Anson's Solicitors podcast, the first of what I hope are going to be many informative podcasts where you get the chance to meet the people who work with and for us, but also to introduce you to some interesting and hopefully helpful areas of the law. I am joined today by my colleague, Jason Alcock, who is the head of our employment team. We'll get into, so you can get to learn a little bit more about Jason as we go through this. But today we're going to concern ourselves with one big change which has come into force over the last month concerning the regulations around harassment and a new positive duty to prevent harassment. And then we'll move on to perhaps some of the more interesting topics and quite radical changes that the new government are meant to be introducing over the next 12 months, which could include unfair dismissal rights from day one, right to flexible working requests from day one, and finally, perhaps, as I say, looking down at my own phone, the introduction, which I think they've got in France, of a right to switch off. So we'll go through all of that. But first of all, Jason, can you tell me a little bit about yourself? How long have you been at Anson's?
Been at Anson's for 7 years. Joined at 2016 and been a solicitor for 16 years. Mainly
around the Lichfield area. Had a little bit of a stint in Coventry at one point, I seem to remember.
Trained in Lichfield, then specialised in employment law, did pure employment law for 8-9 years over in Coventry, and then came back to Lichfield to go back into more general litigation and employment.
And the interesting thing about Jason, or mine and Jason's relationship, is that I recruited Jason whilst we were on the other side of a case to one another many years ago. And I always say that Jason was the one person to sort of inhibit his own firm's financial performance before he joined it by very successfully defending that claim. Which meant that we didn't get the victory and all that would have come with it. But I guess that's just showing that you're professional till the very end, really.
Absolutely.
Okay, so just in terms of the changes that have come into force this month, so this is a law that was passed by the previous government, and that concerns harassment. What's changed there?
So there's now a new positive duty to avoid harassment, which means employers have to actively take steps to prevent it from happening. It's moved to a preventative regime, and it's designed to force employers to look at it, to face into it, and to deal with it. To a degree, it's always been there. The anti-harassment legislation has been there for many years. It's been enshrined in various legislations. Obviously, most recently was the Equality Act back in 2010. And employers have always had not a positive duty, but they've always known that they've got to do something about preventing it, in the sense that you always had a defence to a claim where you had taken all reasonable steps. So To say it's something completely new wouldn't be fair, but it is very much now saying actually employers have to do this, not they should do it or not that it gives them a defence to something. It's forcing them to do something about it now and to look into it and to deal with it.
So, I mean, my understanding would always be, and you might have heard lawyers use this phrase, vicariously responsible, but what that in effect means is that often an employer can be responsible for the actions of an employer can be responsible for the actions of their employee, and in different areas of law, that might mean that an employer is responsible for their employee crashing the works van and doing damage to a sign or a bollard or something along those lines. And presumably in harassment and discrimination law, an employer potentially has always been on the hook for harassing activity of one of their members of staff.
Absolutely. So that is definitely employees, could be workers, could be agency workers. The difference is, though, third-party harassment isn't something that an employer necessarily is going to be on the hook for. So something that a contract and somebody that they didn't have any control over, if you like, they're not going to be on that hook. That said, although the legislation doesn't go that far, my own view is why wouldn't you take steps to make sure your staff are protected?
Well, I mean, I think most good employers would do that, and I guess what's changed now is the law is seeking to impose an employer takes proactive steps, and it isn't just enough to sort of sit back and have a policy which sits in a dusty, years ago would sit in a dusty staff handbook. I guess these days it's on a intranet site, but it's never particularly looked at beyond the first day, perhaps, that somebody is employed by someone. You would need to be doing certain risk assessments, and
so we'd expect that the policies are always going to be there. As you say, why wouldn't you have them if you're going to have a defence to any claim in the future? But I'd expect to be seeing employers picking those up, dusting them off, checking what's actually in them and making sure they're up to date and appropriate. I'd expect to see training so that the employers are training their staff as to what is acceptable and what's not acceptable. Equally, I'd expect employers to be looking at nominating a person to be responsible for it, somebody that can be proactive and that can look at things around preventing harassment in the workplace, and that can be, and I'd expect them to do a risk assessment so they can work out exactly what it is and where the risks are, and they can then work out what they can do to stop those or mitigate those risks. I
read something recently in one of the newspapers, or more likely online actually, who am I kidding that I'd actually got an actual newspaper in front of me, the headline being, "Is this the end of the Christmas party?" Now, I would guess, and I'm thinking back to the sort of earlier part of my own career, that, even in law firms, those things could be sort of, and often around the country used to be quite leery occasions. These days, younger generation, sometimes I suspect a Pepsi Max is the more likely drink at certain social occasions than a pint of Worthingtons. But still, I guess just asking that question, is it the end of the Christmas party? I
don't think it's the end of the Christmas party. I think there's always going to be an awful lot of scaremongering around this subject. And part of that comes because historically these Christmas parties will be alcohol-fuelled or there'll be alcohol involved. And there was the scope for people to act how they wouldn't normally within the office. And so, yes, that has always been an attractive thing. And there's always been a bit of, you better watch that anyway. But in terms of the new regime, it's not saying you can't do fun things. It's not saying that you've got to completely cut out any place or any risk at all. But what it's saying is, look, you've got to look at this sensibly and you've got to take precautions. So rather than having a Christmas party where there's a free bar entirely, you might say, well, we'll give a couple of drinks to everybody, or you might say we won't provide the drinks at all. Equally, you'll set it up so that There's somebody that's going to be responsible there. And part of all of this is not just about trying to prevent something, but equally acting quickly when something does go wrong.
Yeah.
And so you can see that there's going to be, particularly around the Christmas party, if there is allegations, A, there's going to be somebody to step in, and B, there's going to be something done about it. And it's not just that's okay, it's the Christmas party. That won't be acceptable.
A bit more proactively making sure everyone goes home safely, maybe.
Yeah, I think there's a good part around that, and just being a reasonable employer and realising that the employment isn't restricted to the 9 to 5 or whatever the hours of work are. And if you're doing something outside of that, it could still be classed as a working environment.
Yeah. A manager who is WhatsApping, a colleague of a colleague in the evening, potentially, some of it could stray into that, really, right?
Yeah, absolutely. And where that is happening, it's about putting in a reporting line. So if somebody feels that they are having a situation where they're uncomfortable, they can report it. And then so that the employer can step in and can do something about it and can look at those things and deal with them. And equally, where you're talking about things like WhatsApp, I know there's this myth that all of that is encrypted and all of it's private. Well, it's not. And once somebody discloses it, I think there probably is a training piece around actually for everybody. Just be careful about what you're doing online.
One of the things that occurred to me is that even though the legislation itself has not changed, and fundamentally the law of harassment has not changed, and it's almost the creation of a separate positive duty to, in effect, act proactively, I suspect that an employer who is in the tribunal facing unfair dismissal / sex discrimination claim based on an act of harassment, if they can't point to anything or point to much beyond a policy that no one's ever looked at as to the steps that they have taken, whatever the law says, the chances of a tribunal bench seeing the employer has done very little or nothing, the chances of that bleeding into the decision around the harassment itself and whether that constitutes discrimination or an unfair dismissal, I think the chances are that the two things are going to be intimately tied together, right?
Yeah, I think that's got to be right. And particularly, I mean, what we've got to remember is what the new law is doing. It's putting the positive duty on. And if employers don't do it and they are found to be liable for harassment, it increases the compensation at the end. So it's an uplift of up to 25%. But what we might also see is on the unfair dismissal side of it, if the two are linked together, then it's easy to see how it might be attractive for an employee to run a breach of mutual trust and confidence type argument saying, well, you didn't do something to protect me and the harassment was a result of it. And in which case you can see how judges may get dragged into taking the liability part.
So if somebody's watching this and they need to sort of compose a quick list of actions to take, first of all, actually, dig out your existing policy and have a read of it to check that it is compliant in terms of the new legislation. Yeah. What else would you have them do?
I'd also double check the contract and just make sure, and most employers will have the equal ops type clause in there somewhere, and or in, say, disciplinary policies, they'll have something that amounts harassment to gross misconduct. So you'd want all of that, so you've got A, you're showing you're taking it seriously, and B, you've got a set of tools that you can use if it arises and you can deal with it. In terms of other steps outside of that, I'd like to see employers starting to nominate somebody, and that might be one or two people within the business.
The harassment champion, obviously anti-harassment champion.
Anti-harassment champions, yeah. Somebody who can take a lead on it, somebody where there can be reports to, somebody who's actively reviewing those policies and procedures so that they're not just going in the back of a cupboard and being forgotten about. Somebody who's looking at it, you'd expect them to be looking at it at least every 12 months, if not more frequently.
And is there us lawyers are terrible for suggesting this, but is there a risk assessment that needs to be done?
There's always a risk assessment that needs to be done, particularly in these, and you're looking at where is the risk of the harassment and what can you do. You're never going to be able to remove it altogether, but what can you do to reduce that down? What can you do to mitigate it? So, for example, when I've done ours in conjunction with one of our colleagues, one of the things we said was some of the networking where it's where you could end up with a drinks night or something, and you send along junior members of staff. How do you reduce that down? Well, one way could be you always send them, at least two of them, where they're into that sort of situation.
Travel together.
It's all of that. It's looking at what we're never going to be able to take it out altogether, but we can mitigate it and we can make sure we've got steps in place. You also want to put things in. You want to let your staff know that there's a place to report it. So there's some training here. So, I mean, it's part of perhaps the next time you're doing some training to your staff generally, that at least there's a section on that, perhaps? Absolutely. On what harassment is, what won't be tolerated, where people don't always accept that, they don't always understand what the difference is between harassment and a bit of banter. Well, there's a very fine line, and try and stop people from the education of it will try and reduce that crossover, but then telling them about what they can do if they are feeling threatened. And again, it comes into having a single person or a couple of people that you can report it to. And if a company or an employer is getting reports, they've got to do something about it. It's not enough to go, oh, well, never mind, it's not my problem. It is their problem. One, because they risk getting sued, but also it's got much wider implications than that on a business front. I mean, if you've got harassment in the workplace, it's not going to be very pleasant. So you're going to have issues with retention of staff. Yeah. You're going to have issues with trying to recruit people in. And it's going to make life much more difficult. So actually, why wouldn't you take the steps?
Oh, and also in this modern age where, if you are subject to a tribunal claim and it does end up in a tribunal, it will be all over the online press. It will be shared. Everyone will get to know. The real damning for a business's reputation. The reputational risk is huge. And I think whilst you say that, an employer can never completely eliminate this sort of thing, you would at the very, very least, faced with a claim, even, a claim that you can't defend, you would at the very, very least want it to be recorded that, the positive, proactive steps that you took to create an environment where there was less of that.
Yeah, absolutely. And let's face it, there's two things to think about whenever you've got a claim. One, the sheer cost of them, and discrimination, harassment claims, just to run them and defend them are, you're going to spend tens of thousands of pounds. And secondly, there's nothing worse than seeing that headline that says such and such accused of harassment of a member of staff. Case continues. It doesn't even have to be that.
No. This is one of the things that I've always noticed that salaciously the newspapers will publish the account of the allegations, and then sometimes even if the employer is cleared, wins the case, there won't be a follow-up article, or indeed even the article itself will not be updated to say, oh, and by the way, tribunal completely rejected all of this. And
or if it is, you get the initial page 1 and then the follow-ups on page 5 that nobody reads.
Yeah, or on some article that doesn't link up. So that is a piece of law that has changed recently, as we say. It's coming into force this month, depending on when you're watching. Certainly this autumn, depending on when you're watching this podcast. We have had a change of government this year, and both in terms of their manifesto and in terms of what we've heard since they've been elected, since the election, beyond the fact that we're all going to be impoverished following the budget. That's not particularly been a lot of we'll be told, but it strikes me as a little bit like Dad's Army and that we're all doomed. But there are some changes coming that have been sort of flagged up. And in some respects, actually, we've had the harassment legislation update. Maybe the line in employment law was, every March and April there was some significant changes. For the first probably decade of my career, there was always something significant happening in the employment law space. Maybe for the last 4 or 5 years it's been quieter, but that is about to change, right?
Yeah, that's right. I mean, we've certainly, with the new government, we've seen this threat of a change on the unfair dismissal legislation. The jury's out as to what that looks like. And just so that we clarify what that is, they're talking about bringing in the right to bring a claim for unfair dismissal on day one of the employment. So somebody starts, and if they're sacked at the end of the first week, potentially unfair dismissal becomes unlocked to them. Whereas at the moment, you've got to wait 2 full years normally, unless you can fit into one of the exemptions.
So yeah, I mean, I've seen this go back and forth over the course of, it's a bit like the VAT rate or something like that. Whereas when I started in 2001, it was 2 years. Then I think in 2010, it went to 1 year, but also you had to pay fees.
Just before that, yeah.
The fees regime was removed, but they did push it back up from 1 year to 2 year, and now it looks like it's going to go back from not even 1 year, but down to, in effect, on your first day, you could be unfairly dismissed. That's quite a radical change.
It's very radical. It's very radical to give the right to everybody. But part of me wonders whether the logic to it is, as I mentioned, there are claims that you can run for unfair dismissal where you have got under 2 years service. So, for example, if you've raised unprotected disclosure, if there are
harassment.
Yeah, absolutely. And one of the things we did see when they increased the cap from 1 year to 2 years was that people were trying to get other things in and trying to run other claims, having raised a statutory right or having done something. So they'd pin their colours to that claim. And the problem with those claims are, A, they're more difficult and they're more technical in nature. And secondly, they take longer to run because it's all about the tribunal getting into the mindset and working out whether the dismissal was because of that thing. So I do wonder whether part of it's trying to simplify the process.
Yeah, so that you haven't got, all of the cases aren't trying, if they've been employed for less than 2 years, they're not trying to shoehorn in a protected disclosure to give them the argument that they've been unfairly treated or unfairly dismissed, in effect.
Yeah, absolutely. So I can see the logic to it in that sense. But from an employer's point of view, I mean, this could be massive. I mean, it's the difference between having a trial period for somebody to be in and letting that run and being able to dismiss. And you can, at the moment, obviously there's probation periods, but there's a 2 year period.
Yeah, I mean, I've often said to employers that, that in effect, probationary periods are in most contracts, but in terms from an employment law perspective, were largely irrelevant. They were contractually irrelevant, but they weren't in terms of you being exposed to a claim. And up to a point, provided you didn't fall into one of the protected categories, for the first 2 years of somebody's employment, you could just decide that their face did not fit and that they could be dismissed, and there to be no repercussions in that regard. Now we're moving, that can happen on day one. It almost turns it on its head, and a probationary period, which for most employers, and it's a two-way street up to a point, is an important part of employing someone to assess whether or not it's working out or not. I mean, the importance of those, well, I mean, are they getting rid of probationary periods? What's happening there?
It doesn't look like they're going to get rid of probationary periods, but we don't have any firm idea as to what this will look like yet. And what the government seem to be saying is, yes, there has to be a period where somebody can be tested to make sure that they're up to the job, to make sure that they will fit within the organisation. What we don't know is what a probationary period is going to look like. Now, the cynic in me would probably say what we're going to see is something that says that, as with a lot of employment law, and like most areas, we always get this just and reasonable thing put in.
Yes.
So I suspect what we will see is unfair dismissal from day one, subject to a just unfair, reasonable in all the circumstances, probation period. Question, what's that going to be? And I think the answer is, I don't know.
Although I'm a survivor of, I don't know if this was slightly before your time, but I'm a survivor of the statutory disciplinary process, the legislation that was introduced. I'll get it wrong, but like 08-ish, around that time, maybe slightly earlier.
Earlier, I think it went about 06, 07 off the top of my head.
It went as it was introduced, or they abolished it?
They abolished it.
Well, and when that came into play, it was very prescriptive, almost like sort of French legislation or something, whereby it literally set out
what you had to do.
Everything that you had to do, and in an order, and to the point whereby claims were being brought just because, you know, the letter didn't specifically say what it had done, and all of that sort of stuff. There's lots of technical.
Flip side of it, where claims have been stifled because, and particularly around the grievances, it was what amounts to a grievance, and lots of satellite litigation as to whether a letter that wasn't clear on face value was a grievance, or whether it had to be headed up fully, or equally, you'd get disciplinary processes that weren't followed through properly. Now, that's not to say it couldn't be an unfair dismissal, but employers were found to be not automatically unfair, but they were found to be unfair for not following the process. And I remember it well because there was a lot of talk of how it had become too litigious and how lawyers were taking it too literally and to the letter. And so, yeah, I think we're going to have that again in terms of what is a probation.
I mean, when the law is drafted like that, you have to. I mean, there's no getting around it. Employment law is largely a creation of statute. You know, doesn't really exist before the 1970s, and it is, you know, a large amount of regulation and legislation. When it's drafted like that, and hopefully they don't go down that route and they do what you're suggesting, a sort of, you know, reasonable in all the circumstances probationary period, and hopefully, and there will be satellite litigation, there will be case law on this. I am hoping that the tribunal judges, how the law goes is they will say, well, listen, just and reasonable has to be determined on the facts of the case, and there isn't a lot of precedent to be set around what a reasonable probationary process looks like, much like we see on the restrictive covenants. You know, the law isn't particularly prescriptive there. I think that hopefully if it's like that, it should be workable and it doesn't go back to those statutory disciplinary procedures.
Will, but for the first 12, 18 months of it, whilst we're getting to grips with it, it's going to be difficult, and there's not going to be a set answer, which makes it harder for us as lawyers to be able to advise as to what that looks like. And what I suspect we'll see is a lot of litigation around A, what's reasonable, and B, what then becomes acceptable within it, and what might make a 12-month probation period acceptable for something but not for others. So, yeah, I wouldn't expect to see a cleaner with a 12-month probation period, but...
Yeah, you could see in an accountancy practice, you'd want them to get through 1 January where they have to do everyone's tax returns, for example, and that, you know, if you employ someone in February, you wouldn't almost be able to know how good they were going to be until you'd got through that first year when they've almost done everything that you would do in an accountancy practice, I would imagine. Yeah.
So I can see that we're going to end up with a lot of discussion around it.
And a lot of cases, and I guess the thing that would cause me a lot of concern, and we're seeing this in our interactions with, you know, the court service generally, courts and tribunal services, there's going to be a lot more claims. That seems inevitable if you're lowering the hurdle to bringing a claim. And my concern here is just how long some of those claims are going to take to get listed, and what are we talking currently around here?
Depends on which tribunal we're looking at. If you're looking into Birmingham, certainly anything issued now is not going to get heard until, at the earliest, sort of, if you're lucky, March next year. But realistically, if it's an unfair dismissal, probably 12 months from now. You know, if you're looking at some of the London tribunals, you could already be looking into 2026.
Oh, so well over a year to get to a final hearing. Hopefully, there'll be some more resource to the tribunals that's provided. We'll see if there is or not. I have been. I said earlier in this piece that I don't do so much employment law these days. I've been quite impressed recently, actually, with the role of, perhaps I was just lucky to get the right case handler, but the role of ACAS in claims and trying to push sort of these claims settling or being resolved at an earlier stage. Is that your experience, or are you found it less?
Certainly ACAS have their place.
Yeah.
Certainly early conciliation was a good idea.
Yeah.
It forced parties to think about it rather than just doing battle and thinking about it at the 11th hour. Some of the conciliators are brilliant, others are less proactive, and all they want to do is pass on whatever you've said, so you're really not getting...
You feel like it's a postal service for email, in effect,
yeah? Pretty much, yeah. But look, if it makes the parties talk, regardless of how that happens, it's got to be good.
No, well, listen, the one I was involved in, I was really quite impressed with the conciliator, and maybe I, on that case, got a good one, but it sort of gave me a bit of hope that, they're getting some good training and they were operating a good service. So these days... And again, I know I'm trying to age myself here, but with email and that sort of thing, you're not waiting for a week for a letter to be opened and read and everything along those lines. And I must admit, I was really impressed with the service that I got.
I suspect they'll have a bigger part to play with the increased number of claims that will come from the removal of the 2-year the 2-year requirement, and there'll be a big place to play in that for them. Dealing with sort of filtering through the claims and trying to get a lot settled at an earlier stage. In terms of that, just to finish off that sort of part of the discussion, I think the one thing we could say to all employers is, look, actually, will it change anything? Should it change anything? And the answer is no.
No, well, I've always said this. You've always been a great advocate that if you are dismissing an employee because of the fact that you theoretically could bring a claim, you've always been a great advocate of following a process if an employer's been there for 1 day or for 10 years, right?
Absolutely. I mean, if you go through a process, one, you document exactly what's gone on.
Yeah.
You've given the employee the chance to comment on it. You've considered it and you've made your decision.
And they have a right to appeal it, right? Always really difficult for an employee to say this process was unfair. It was so unfair that I didn't bother to appeal.
Absolutely. And it just uncovers anything else that might be lurking in the background that you're not entirely aware of. And it just justifies that employers have then gone through a process, they've considered it fully, they've not made any rash decisions, and they can, if you're doing the process, you also have to document it.
Yeah.
So you've documented exactly what you've done and why.
And also from the employee's perspective, it's only right that there is a process that is being fair to people if they're losing their job, to have it explained to them what the reason for their dismissal is. It is important, right?
Yeah, it's got to be. From a human point of view, it's got to be.
And if you want to be an employer that people want to work for, sometimes how you treat people on the way out is more important than sometimes how you treat them on the way in, right?
Yeah, I think that's right. I mean, let's face it. If somebody gets kicked out tomorrow with no notice, no explanation, the first thing they're going to do is run down the pub to their mates and say, this pack of whatever they want to call them have just done this to them.
Run down the pub for a Pepsi Max. I thought we already established that no one's drinking these days. So
Pepsi Max it is.
Now, so as it stands, they're probably, in terms of a call to action here, unlike the legislation that's just come in place in terms of harassment, is there anything, I'm banning the word risk assessment here, by the way, but is there anything that you could say that the employer should be looking at now?
I'd say look at the processes, make sure they've got a robust process in place and a policy that says this is what we're going to do if we're going to dismiss somebody for a misconduct issue or for a capability issue. And have a think about what they're going to do when the new legislation comes in. Are they going to have a full policy, or are they going to have a stripped-down version of it so that it's quicker to deal with? So you're not going into, particularly for capability, you're not going to go into a full, we're going to give them this time to improve, and we're going to do this, and we're going to do that, and we're going to do the other. But you should still be having the basic, right, okay, there's always going to be a written invite. We're always going to give them the information that we've got, that we're, of reasons we're not happy. We're going to have a meeting with them. We're going to set out our decision in writing, and we're going to appeal. Just have something there ready and be prepared for it.
Okay, so as I look down at my mobile phone, one of the interesting, which is fully emailed up, I can get emails any time, day or night. I had a couple before 7 o'clock this morning that I looked at. There is a new right coming on stream, the right to disconnect. What's that all about?
It's the idea that in today's society, we can be too readily available and people can start to expect staff, employees to be available. And let's face it, we've all got emails to our phone. We've all got mobile phones. We've all got WhatsApp and
other messaging services are available, but not as good.
Not going to comment. But and it's the idea that actually you're employed to work between certain periods, and when you're not working, you should have the right to unplug. And it's really following on from what other places have already started to do. I think France may have brought it in. Ireland have certainly brought in a code about it. Australia have brought a code about it. And it's the idea that people aren't on tap 24/7. They're not supposed to be working all the time. They can't be expected to be working all the time. And therefore, if they aren't working and they want to unplug, they should be able to, and they should be able to. And that's got to be right, because otherwise you're going to end up with more stress issues, more burnout issues. From an employer's perspective, that's also going to lead to more absenteeism, likely through illness.
But I assume in the countries that have introduced this, I mean, where my mind goes to is, I don't know, a doctor on call or indeed any sort of on-call worker, there's going to be a method of communicating with those people. We anticipate that will be permitted, I assume.
Of course, there's going to be an on-call element, but you're going to know you're on call because you're going to be signing up to something. And certainly even in this country, a lot of the sort of public servants that are on call, they're on call during certain hours for certain periods.
Right.
So they might be on call for 7 days in a month, but they'll know when those 7 days are. So, of course, you're not going to be able to unplug when you're technically working. And often when you're on call in that way, you're paid to do that as well. But if you're outside of that, you're not going to be able to be contacted if you don't want to be. That's not to say in an absolute emergency you wouldn't be able to be contacted, or if there's a real problem that the employer couldn't get in touch with you. But I think the point is that you can reduce that much more down. So it's not going to be a normal thing for you to be contacted outside of hours any time that the employer wants you at their beck and call.
Albeit, again, hopefully framed in terms of reasonableness and in the circumstances of it. There's lots of jobs, thinking of solicitor with a deadline, when something changes at the last minute, which from time to time, unfortunately, means you're going to be working maybe at home or maybe into the evening. And whilst you hope that that's not happening for, 5 days of the week, 12 months of the year, there will be times when that is necessary.
Yeah, I think that's right. It's like with everything else, the devil will be in the detail. It's going to be a balancing act between the needs of the employers to be able to react quickly to things and the rights of the employees not to be harassed. Harassed, probably the wrong word. But not to be constantly on call, sort of unofficially, and can be dragged in at any point in time, 7 days a week if they wanted to be. There's got to be a balancing act.
The devil's going to be on the detail on this one, and I think we've gone however far through this podcast without me saying that phrase, but it was inevitably going to come. But let's see with that one. I think that. I think I can accept the principle of the need to have something like that in play, but practically, if it isn't implemented with balance and reasonableness, it could be something of a disaster. It could.
Practically, I suspect we won't see statute on it. I suspect we'll see statutory guidance, and a bit like the other guidance codes. And the advantage to that is, of course, that the tribunals don't have to read it absolutely strictly to the rule, and it's got a bit of scope to sort of
and probably, I mean, under the existing law around unfair dismissal, constructive dismissal, an employee who is constantly being bombarded with messages into the evening about work-related matters, even as it stands, could say, well, hang on, you're in breach of my duty of trust and confidence, and therefore that constitutes a situation where I'm constructively dismissed.
Potentially. You could even have a breach of the actual terms of the contract. Because if the contract just says you work 9 till 5 and doesn't say, and you'll work other hours reasonably required, well, if you're contacting them and forcing them to work in 6, 7, 8, 9, 10 o'clock at night, well, actually, you might have a breach there. So, yes, there could be constructive dismissal claims already in that sort of zone. I think what the guidance is aimed or will be aimed at doing will be to say, look, the world has changed and that we are aware that this is happening. This is an idea of what would be acceptable conduct. This is stuff that is going beyond that. And actually, employers really need to think about what they're doing at this point.
I've always thought, even from a risk management perspective, that what certain employers do, I'm told in particular the banks, but I do know some professional services firm do, is sort of cable cut when people say that you can't be accessible, and almost literally switch it off at source so that so that emails don't flow through when somebody's on a 2-week holiday, and it's compulsory to have at least 1 2-week holiday a year. And I think that can certainly aid employees' mental health in the long run. But also, I guess it's the opportunity to just check up on your employee while they're away and unable to sort of influence what's happening, if I'm being cynical there.
Absolutely. But
probably a positive.
Most employers will already, I would hope, have that ability, particularly where you've got somebody with stress, anxiety, mental health issues, and they get signed off. You'd hope they'd be able to turn off the emails and things so that they're not being bombarded with that. So I suspect all we're going to see is an extension of what we already know and a codification of it so that we've got a better idea as to what we can and can't do. And that will help both parties to understand what is reasonable and what's going beyond the realms of what should be happening.
The final big change I wanted to discuss today is in relation to piece of law that is already there, but is to bring forward the right to request flexible working from day one. I think it's important to stress it's the right to request flexible working. It's not the right to have flexible working.
Yeah, that's right. And I mean, this has been around for years. It's not a new thing.
What's the current period that you need before you can have the right to make that request?
It was 26 weeks, but that's now going. That's gone. And the other thing that's
after 6 months, basically.
Yeah, and it's been brought forward, so it's a day one right. But the other change that was made this year was before you could only make one request in any 12-month period.
Yeah.
Now you can make 2. So the idea is you can't just kick it into the long grass and that's the end of it for 12 months. The employee can still come back.
And just in terms of that, an employee, if they need to perhaps change their working hours, maybe work hybrid, maybe move from being full-time to part-time. Is it those sorts of...
So the flexible working is 3 things. It's a change to your working time. It's a change to when you work your working time. And it's a change to where you work.
Right.
So it can be any of those things. And you're right. Where the media got it wrapped around its neck the first time round was it was saying, oh, everybody's got the right for flexible working. No, you've got the right to make a flexible working request. And a flexible working request is either a temporary variation to your contract, not I'm going to come in at 10 o'clock and leave at 4 o'clock.
Yeah.
And I'll do whatever I want each day, depending. It's okay, I've now got childcare responsibilities. I can't start work at 8:30. I'd like to start work permanently at 9 o'clock. So it's either a long-term temporary thing, or it's a permanent change.
They've cancelled my child's after-school club this term because, whatever, the music teacher's not around or whatever that might be.
Absolutely.
Now, as it stands, that right was a right to request. An employer would then call a meeting to discuss it and then would give their answers and, and put that out there. And that's not changing.
It has changed slightly.
Yeah.
Because before, the employer had 3 months in which to do something. So they'd call the meeting pretty quickly, and then after that could take their time, which often was a bit of a frustration point. And by the time you dealt with it, the circumstances had changed, or the employee just got really annoyed and left. But that's now been reduced. That's now only 2 months. And yes, it's what the rules around it are make an employer consider everything that's put forward properly. That's not to say that because a request has been made, it's got to be granted. What it's forcing the employer to do is to consider any request properly and fully and fairly. But it's not to say that they have to grant the request. And without going into too much detail and on the specifics, the Employment Rights Act has a section where it actually gives you a series of reasons for which you can refuse. So it's around your business needs. It's the can't recruit to fill the void. It's a detriment to service. It's not being able to deal with the role that needs to be filled.
Although there are those reasons there. My practical experience with these requests is that actually a high proportion of the time, partly I think due that those requests are granted actually, or at least some sort of compromise is reached between the employer and the employee. I suspect that's partly because when that meeting occurs, the employer can understand the circumstances which their employee is facing and wants to accommodate them, particularly in a world where recruitment of good staff is tough and potentially expensive to replace them. And a lot of the time I have found, and perhaps the cynic in me didn't think this would be the case, but at least some kind of accommodation is reached.
Where the flexible working requests are reasonable, absolutely. And the advantage of that discussion is you can talk around it and say, well, actually, what you've requested doesn't quite work for us because of A, B, and C. But what we can do is we can offer you option D instead. Yeah. But it's all going to depend, and every circumstance is going to be different. So, for example, somebody who's stacking shelves that wants to put a flexible working request in to work from home is never going to work for obvious reasons. Yeah. But somebody that's a member of staff, an admin member of staff that wants to come in a bit later or leave a bit earlier, it may well be workable. Equally, sometimes you'll see requests where people want to step down. Often you'll see these where people have childcare responsibilities. They want to step back from doing 5 days and do 3 days.
Yeah, I mean, some of this is the unfairness that, in work generally, right? Somebody working for the postal service is going to find it difficult to work from home. A bricklayer is going to find it difficult to work from home, right?
Exactly. But that said, there might be synergies that can happen. So although you might have a site worker, if you've got a site worker that's, let's say, doing surveys and they do 3 days on site doing a survey and 2 days writing those up, if they come in and say, well, can I work from home for 1 day a week, but I'm not going to pin it, and it'll be whatever day I'm not doing my site service, well, that might work.
Yeah.
And it might work, and it might be advantageous to everybody.
And I wasn't so bothered, I don't think, in terms of it being sort of employment myself, I guess, in terms of it being a day one, right? Because quite often when I've employed people and they've got a notice period, it's not that unusual for something to change between when they've accepted the job around hours and when they actually begin work, and they will get in touch and say, well, look, my son's nursery has changed its opening hours. I can't get in anymore for whatever it might be, 8:30. It's going to have to be 9. And I guess in those requests were coming in anyway, even if it wasn't part of a statutory regime.
The difference is this is just extending that period, and it's giving the employees that right to make the request.
No doubt, I guess some employers would be aggrieved to have offered somebody a job on certain set of terms, and then on the first day the person wants to change that. But
again, it's looking at 1, what's in there, 2, what works reasonably, and 3, just considering the request. It may not make a difference. And as you say, if you'd have agreed that pre-signing the contract, you might take a view of, well, okay, it's day 1, doesn't really make a difference. It's just about making employers look at it, think about it, and deal with it.
This is going to come in, and I think is going to come in relatively quickly. So in terms of taking steps now, what would you be suggesting?
I mean, they should already have provisions in place for dealing with the flexible working requests. Yeah. So all you're doing with that is making sure the policy's there, making sure you're following it, making sure you're aware of that slightly reduced time, and making sure you're aware that, yes, they can make it on day 1. And not only can they make it on day 1, they can make that second request within the 12-month period. So off the top of my head, it's not meaning that they can make one on day 1 and then one on day 2.
Yeah.
They could do if they're materially different, I guess, but normally you'd expect it in one. Why do that to yourself as an employee? But from an employer's perspective, they have to deal with the first one, and then there's a couple of months before the employee can raise the same request again. But as long as they've got the policies and procedures in place, just follow them. Follow them, look at what's being presented, and don't make knee-jerk reactions to them. Go away, have a think about them. Don't feel they've got to give it's not here's the meeting, here's the response straight away. Yeah. It's here's the meeting, okay, what evidence has the employee given you? What's the reasons for doing it? Then go away, and if you don't think it's possible to do it, make an offer of an alternative, if that's possible. Some cases there won't be the chance to do it, some cases it won't be appropriate. But if there is, don't be afraid to turn around and say, look, we can't do this, or we can do this part, but we can't do this part, but we can do this instead for you. And it's about having, more than anything else, what that gives the employer and the employees a forum by which to discuss things. And often, if you discuss it, it'll come out in the wash. And as you say, 9 times out of 10, people will look at it and think, actually, we can do something around this, or this is where there's scope to do something with.
Well, whether or not there's been that many changes, and you've sort of suggested to me there has, but whether there's not been that many changes over the last sort of 4 or 5 years, from an employer and employee perspective, employment law is going to be changing and has changed already over the next 12 months. So we would encourage all of our clients and potential clients to get in touch with Anson's, and we've got expert employment lawyers who can advise you on the steps to take. We also have developed for employers a retainer service. Could you talk them through that, Jason?
So we offer the retainer service. It's called On Call, and that offers an unlimited advice line. That means you can phone any one of the employment lawyers in the team.
Provided it's before 6 o'clock.
Yeah, not silly times.
That was the joke I was making there, Jason, around the right to disconnect.
Didn't get the joke.
It went straight over your head, sorry. Yeah, go on, keep going.
We as part of the scheme, we also have a document library, which the client will get access to, and that's got in it some useful guides as to how to do things, in case they want to read up on it themselves or if they want a refresher. It's got a load of templates on different things, from employment contracts to processes and procedures to staff handbooks to bits and pieces to letters that they might want, to memos they might want to send, in all sorts of situations. So that might cover grievances or disciplinaries or redundancy situations. But that's not meant to be there as a replacement for the lawyer. That's so that they can use those, but then they can have it, if they want to have a go at drafting them themselves, they can do. Or so we can point them to them and say, look.
The big key to this is, lawyers are classic for use the phrase retainer. It's an all-inclusive. Yeah. For the terms and conditions apply, of course, but it's an all-inclusive service whereby we can walk you through, for example, as we've discussed today, a flexible working request, help you write the letters, help you write up the responses, and guide you through that process. Often, correspondence is often better if the employer has gets quite involved, and they have to, but we can help them and guide them through that process.
Yeah, and the whole purpose of the scheme is to try and get us involved early so that we can try and head off some of the problems.
And the all-inclusive nature means that they don't need to be worried about, the dreaded hourly rate or the cost getting out of control, because they're paying their fixed quarterly or monthly fee, and it means that, it's all included within that. And then I guess finally, I've always thought it's quite attractive for employers who just haven't got anything sorted for a while. As part of our onboarding there, we do a review of the contracts of employment that the employer has got and help them and put in place a new staff handbook, or update their existing staff handbook to ensure they're right up to speed with the existing legislation.
Yeah, absolutely. And what a lot of employers, particularly at the moment, won't have realised is, particularly around the COVID time, there was a piece of legislation that came in that said, actually, within your contract, you've got to have other information in. So even if they've complied with the sort of early stuff from the Employment Rights Act Section 1, that's actually been updated in the last 4 years. So there's bits they won't have. And I'm seeing that quite frequently.
Terms and conditions that people did get sorted out, but haven't got all of the different headings in there.
So they're now out of date, and that can be dealt with. We can pick up all of that. And as part of the scheme, we'll either add into the contracts they've got, or we can just give them new contracts to issue out. And if we're issuing new contracts, we can deal with it by types within the business. So it can be as big or as small as they want it to be. It's, we work with the employer to get in place what they need.
And ultimately, we would say employers and employees, get in touch if you need some expert legal advice in relation to employment law. We'd be happy to help.
Absolutely.
Thank you, Jason.
Thanks very much.